Good evening, my beautiful people from Edo State and lovers of good governance. It's me, your brother, your friend, Mr. Open Letters, and to Nigerians in general, and to my lovely supporter. This evening, I have with me a copy of the judgment of the Edo State Electoral Petition Tribunal given by the Tribunal panel Justice Wilfred Kpochi on the April the 2nd, 2025, concerning the matter between Dr. Aswerime Igodao and distinguished Senator Monday Ukpebolo, the current governor of Edo State. So I have the copy of the judgment, which I want to read out to you guys, supporters of Dr. Aswerime Igodao, and also the supporter of distinguished Senator Monday Ukpebolo, in order for us to know if the judgment actually went to the gallery of corruption that our judiciary in Nigeria has been known for, in order for us to be able to have a clearer judgment of the matter ourselves. So this evening I have the copy of the judgment, which I want to read for you guys. Please sit back and relax and just listen. It's quite a lengthy one, but you are going to benefit from it also. So we start. It's establishing no compliance with section 73 subsection 2 and section 51 subsection 2 of the Electoral Act. In the Governorship Election Petition Tribunal, in the Edo State Governorship election holding at Benin City on Wednesday, the 2nd day of April 2025, before their Lordship, Honorable Justice Wilfred Kpochi, Chairman, Honorable Justice KB Yusuf, Member, Honorable Justice AA Adewale, Member, Judges, Governorship Electoral Petition Tribunal. So the case is EPT/ED/Gov/02/2024 between first Igodao Aswerime, second People's Democratic Party Petitioners, and first Independent National Electoral Commission INEC, second Ukpebolo Monday Respondents, third All Progressive Congress APC. Judgment delivered by Honorable Wilfred Kpochi, Justice. Fact. So the case is coming in 4 stages: the fact of the matter, the issues for determination, the argument, and finally the court judgment. So we are going to start with the fact. So the fact is this: the first petitioner was sponsored by the second petitioner as its candidate for the governorship election of Edo State, conducted by the first respondent, INEC, on 21st September 2024. The second respondent was the candidate of the third respondent at the election. Upon conclusion of the election, INEC declared the second respondent, Senator Ukpebolo Monday, as winner of the election with a total score of 291,667 votes, against the first petitioner, 247,774 votes. It was against this declaration that the petitioners filed the petition on 2 grounds. The petition was signed on 2 grounds. To wit, 1, the election was invalid by reason of non-compliance with the provision of the Electoral Act 2022. Second, the second respondent was not duly elected by majority of lawful votes cast at the election. The ground for non-compliance with the Electoral Act was predicated on 2 heads, namely the alleged contravention of section 73 subsection 2 of the Electoral Act in 395 polling units, resulting from the failure to pre-record the serial number and other particulars of result sheet, ballot papers, beavers machine, and other sensitive material in Form EC 25B. And the alleged contravention of Section 51, subsection 2 of the Electoral Act, in that the total votes cast as recorded in Form EC8A in 133 polling units exceed the total number of accredited voters based on the beavers record of accreditation. This contravention allegedly comprised of 75 polling units where there was both overvoting and not prior recording, and 58 polling units where there was overvoting only. Regarding the ground that the second respondent was not duly elected by the majority of lawful votes casted at the election, the petitioner complained that there was discrepancies in the result for 125 polling units uploaded by the presiding officers to the IREF, that in 10 polling units, scores entered were not found on agent copies, IREF copies, or the certified true copies of the hard copies of the Form EC8A, and 21 word collation center. The result of 100 there was various objections filed by parties challenging the petition and reply to the petition. There was also objections to the admissibility of document. The tribunal defied ruling on the various motions to delivering of judgment. In proof of the petition, the petitioner tendered several exhibits and called 19 witnesses through whom they sought to establish their claim. The first, second, and third respondents deny all the petitioner's allegations. In their reply to the petition, the first respondent did not call any witness, which is the INEC, but rely on the evidence elicited under cross-examination of persecution witness 1 to persecution witness 19, and tendered 3 exhibits. The second respondent relied on evidence extracted from the persecution witness 1 to persecution witness 19 while under cross-examination, and also called a single witness who was a polling unit agent. The third respondent called 4 witnesses who were local government collation agents. Issues for determination. Now we are going to the second stage, which is the issues for determination. The tribunal considered the following issues for determination of the petition. 1. Whether from the totality of the pleadings and evidence, the petitioners prove that the election of the second respondent as the governor of Edo State was invalid by reason of non-compliance with the provision of the Electoral Act 2022. 2. Whether from the totality of pleading and evidence, the petitioner proved that the second respondent was not duly elected by a majority of lawful votes cast at the election into the office of the governor of Edo State. Now we go into the argument of the case, of the matter. Argument. Issue 1. In a bid to prove non-compliance under its first ground, that is, contravention of Section 73 subsection 2 of the Electoral Act, the petitioner tendered several exhibits in respect of 395 polling units to show the lack of prior recording in the forms before the commencement of the voting. The petitioner submitted that by virtue of section 52 of the Evidence Act, the exhibits were admissible in evidence without the need for oral evidence as an exception to the hearsay rule in section 37 and section 38 of the Evidence Act. They also rely on section 137 of the Electoral Act. The petitioner argued that through these exhibits and the testimonies of their witnesses, they had established their allegation of non-compliance with section 73 subsection 2 of the Electoral Act. On the contravention of the section 51 subsection 2 of the Electoral Act, the petitioner submitted that the number of votes cast at an election in any polling unit is reflected in the form EC8A, while the record of the number of accredited voters in the polling unit is in the beaver's record of accreditation as contained in the beaver's extracts, screenshots tendered and admitted as exhibit. The petitioner then argued that there was overvoting in the 133 polling units pleaded in the petition, as the total number of votes cast exceeded the number of accredited voters, and so the result ought to be cancelled in line with section 51 subsection 2 of the Electoral Act. In response, the respondents were in agreement that the election was conducted in substantial compliance with the provision of the Electoral Act. The first respondent argued, which is INEC, the first respondent argued that it is the form EC25D that is relevant to establish whether the quantity and serial numbers of sensitive electoral materials were completed, and that the said form was neither pleaded nor tendered in evidence by the petitioner, which is the form EC25D was not tendered by Dr. Aswell Igodao or the People's Democratic Party at the tribunal. They did not tender that form, which is the form that is relevant to ascertain the quantity and the serial number and the sensitive material for an election. It was not tendered by Dr. Aswell Igodao in court. So we continue to read. It says, and that the said form was neither pleaded nor tendered in evidence by the petitioners, and this was vital to the petitioner's case. On the allegation of overvoting, the first respondent contended that the petitioner were expected to tender, among others, the voters' register used in the election, forms EC8A, the beaver's device, and call eyewitnesses to relate each document device to specify areas of their case, which the petitioner failed to do also, which means the petitioner failed to call eyewitnesses that will speak to relevant document or devices in some specific areas where there is overvoting, and amongst all to submit a form EC8A, which is the form that record the number of voters, that take the number of voters at the election. So we continue. The second respondent argued, which is the counsel to Mobulu. The second respondent argued that form from analysis before the tribunal, when the scores pleaded by the petitioner were taken into account, even if the petitioner proved the residual of the allegation in the petition in relation to non-compliance with mathematical accuracy and all the votes which the petitioner claimed were liable to be deducted, they were still incapable of affecting the outcome of the election, let alone substantially. He said on overvoting, the second respondent argued that the documents and exhibits tendered by the petitioner to support their case were simply dumped on the tribunal with no witness tendered to support the petitioner's claim. So the second respondent is saying that the document or the beavers that was brought at the tribunal was dumped at the tribunal. No witness was called to talk about the beavers that was dropped at the tribunal. And also, if they are to remove all the overvoting that the petitioner is talking about, it's still not going to affect the outcome of the election. So that is their own argument, which is the argument from the council of Modubebolo. Now the third respondent, which is APC. The third respondent argued that the testimony of the petitioner weaknesses was grossly inadequate, as the weaknesses were not polling unit agents. So APC are saying that the petitioner did not bring eyewitnesses that are polling unit agents, the ones that were really there to know what really happened at the election. So let's just continue to read. It said the third respondent argued that the testimony of the petitioner's witness were grossly inadequate, as the witnesses were not polling unit agents and could not give direct eyewitness evidence as to what transpired at the polling unit. And failure to call the polling unit agent was vital to the case of the petitioner. On the issue of overvoting, the third respondent argued that the petitioner had a duty to prove that the overvoting immune to the benefit of the winner of the election. So what the third respondent are saying, that if you are to argue, if you are to bring this kind of petition, you need to bring eyewitnesses that are polling unit agents. In the all polling units where you say there is overvoting, you have to have a polling unit agent there that can actually give a high witness or testimony of what really transpired at the polling unit. I think, in my own opinion, I think PDP failed in this area. Somehow, you need to bring a polling. I believe they have a polling unit agent. All parties have polling unit agent. Maybe their own was just sleeping that day. The issue 2. Let's go to the issue 2 that was argued. The petitioners argument was that the invalidity of the result of the election in the alleged polling unit on ground of non-compliance, as well as the collation of the lawful scores of the party in the 312 polling unit, were allegations of incorrect collation or exclusion of polling unit results, as the tribunal may find proof will substantially affect the result made at the election. They say, and the petitioners will become winners of the election with 240,238 lawful votes, and the second and third respondent as runner-up with 201,032 votes. So what the petitioners are arguing now is that if they are going to remove all the overvoting and everything, and to actually follow the result and to count it properly, they are going to come out as the winner, because they did their own calculation. So they will come out as the winner of the election by 240,234 votes. And Dr. Modubebolo will be second or third runner-up of the election with 201,032 votes. So let's read further. It said the first respondent contend that none of the petitioner's witness relates the exhibit to the specific complaint in their disposition and evidence in open court. The second respondent position was that ground 2 of the petition was based on the hypothesis that the petitioners will prove the allegation of non-compliance set out on the ground of none of the petition. On the part of the third respondent, it is contended that the law imposed a duty on a petitioner to call evidence from the offices where weakness, I'll come again. He said it is contended that the law imposed a duty on a petitioner to call evidence from the officers who witnessed the exercise at the election ground, where votes were cast, counted, and all collated. Finally, the third respondent submitted that the witnesses called by the petitioners were incapable of sustaining the claim because they were either local government collation agents or ward collation agents of the petitioners whose testimony relates only to what transpired at the collation center and not what transpired in the polling unit as expected by the law. The respondent argued the tribunal to resolve the issue in favor of the respondent. The respondent urged the tribunal to resolve the issue in favor of the respondent. Now we are going to court judgment and rationale. So we are going to the court judgment now. It's a prior to deciding the first issue, the tribunal dismissed objections as to sufficiency of pleading, improper identification of witnesses, allegations of corruption, of corrupt practices in the petition, admissibility of document, amendment of witness statements on oath, and want of jurisdiction. The tribunal, however, upheld the objection as to the introduction of new facts in the petitioner's reply. Deciding the merits of the petition, the tribunal considered the first ground of issue 1 and found inter alia that the petitioner's form EC8As and polling unit booklet were not tendered through proper witnesses that could speak to them. So the judge is saying that the petitioner did not bring witnesses that could speak to form EC8As properly at the tribunal. He said that the petitioner form EC8As and polling unit booklet were not tendered through proper witnesses that could speak to them. That the witnesses were not polling unit agents who witnessed the election process at the polling unit and were not competent to speak to the document to link them to the allegation by the petitioner. And in the circumstances, the documents were dumped on the tribunal. Consequently, failure by the petitioner to call polling unit agents, presiding officers, or even registered voter that witnessed the election at the polling unit was fatal to the petitioner's case. This is what the court says. It's a consequently failure by the petitioner, Dr. Hassan Godao and PDP, to call polling unit agents, presiding officers, or even registered voters that witnessed the election at the polling unit was fatal to the petitioner's claim that they failed to call polling unit agents, presiding officers, or even registered voters as witnesses in their election, in their petition. He said, and that became a very fatal injury to the petitioner's case. And me, at proving no compliance with section 73, subsection 2 of the Electoral Act 2022. On the overvoting, the tribunal held that a petitioner who alleged overvoting must satisfy the threshold in Emmanuel David Obugadu and Anu versus Sule Audu Alaji or Oji 2024, 7 NWLL petition 1936 7 at 113, which is that the document required to prove overvoting are the voters register, the beavers machine. So now the document to prove overvoting are the voters register, the beavers machine, and the form EC8As. Additionally, the petitioner must call eyewitnesses to relate each document device to specific area of his case in respect of which the document will tender, and show that the figure representing the overvoting in new in favor of the respondent, and if deducted would have resulted in victory for the petitioner. In other words, Wilfred Kpochi is saying that the petitioner would have called eyewitnesses to the election, most especially presiding officers or registered voters that will speak to, or collation agent or party agent also to speak to their document, more especially areas where they know there is overvoting, or to document that is tendered at the election. In this case, the tribunal found that the petitioner did not tender the hard copy of Form EC8As, but downloaded the RF copy from the first respondent database. So they downloaded the RF copy from INEC database. So they did not present the hard copy of Form EC8As. He said, and the other document tendered by the petitioner were inter alia, beavers machine, beavers screenshot, and voters register tendered from the bar. The tribunal noted that the beavers machine were not activated or put on by any witness to demonstrate or establish their assertion that this machine remained dormant and were dumped on the tribunal. As such, it was held that the beavers machine were of no avail to prove overvoting, since the content were not disclosed or displayed. To determine the number of accredited voters from each polling unit that the beavers machine were deployed to. Consequently, issue 1 was resolved against the petitioner. Issue 1 was resolved against the petitioner. On issue 2, the tribunal held that when a petitioner alleged that the respondent was not elected by majority of lawful vote cast, he ought to plead and prove the vote cast at the various polling units. He said, I will come again with this one. He said, on issue 2, the tribunal held that when a petitioner alleged that the respondent was not elected by a majority of lawful vote cast, he ought to plead and prove the vote cast at various polling units. The vote illegally credited to the winner, the vote which ought to have been deducted from that of the supposed winner in order to see if it will affect the result of the election. This was hard though. My God. The tribunal held further that where grounds such as lack of majority of lawful vote cast or corrupt practices are raised, the threshold are not contemplated under section 137 of the Electoral Act 2022 and do not apply. It said the tribunal held further that where grounds such as lack of majority of lawful vote cast or corruption or corrupt practices are raised, the threshold are not contemplated under section 137 of the Electoral Act 2022 and do not apply. In the instance case, the tribunal found that results in 23 polling units were not tendered by the petitioner. A number of exhibits tendered were not legible and were not authenticated by the first respondent via its stamp, and as such, it was difficult to ascribe probative value to the document. Consequently, the tribunal held that the petitioner failed to prove the materials required by law for a dispassionate consideration of the issue of majority of lawful votes cast at the election. Ultimately, the tribunal found that even if the prayers for the petitioner grant 2 were granted, the scores the petitioner display in their petition will still be incapable of guaranteeing the petitioner the majority of lawful votes cast at the election. Petition dismiss. That was when they dismissed the case. They dismissed the case because this is what they said. They say ultimately the tribunal find that the document that was brought to the court, which is the beavers, there was not even one witness that could speak to those beavers to specifically say these were the areas on the beavers where this and that happened. And some of the witnesses that they called were not polling unit agents, were not presiding officer, they were not even registered voters. In other words, many of them were not even present at the election ground. That was what they claimed. I don't know. But in all of this, we did, though, we know it happened for that election. Say that election, they ring gam. That election was totally ringed. But me reading this thing, reading the judgment that they give, and if maybe going to appeal court, nothing different will happen. Maybe Dr. Aswell is not allowed to call witnesses to come and speak on those beavers, or call presiding officers, or call polling unit agent to come and speak on some of these documents. I will just be truthful to you guys that I think there will be no hope. It's still going to be the same thing. Because from the tribunal to the appeal court, even to the Supreme Court, they are all working on the same trajectory of corruption. We know what happened in that election. That election was ringed, as in they ring gun. They never say election, they ring past that one. They ringed the election. That election was totally ringed. They know what they did. They know what they did. So, not to bore you guys much, this was the... So, if you know you have an idea of some of the things that I read about and you want to speak about it, you are a lawyer also as a fan, please write your own, what you think about the judgment. Write it what you think about the judgment, and thank you very much. God bless.